climate. We'll now immediately begin our first high-level plenary, Climate Compliance on Trial, with world-leading justices from the European Court of Human Rights, the World Trade Organization, and the International Tribunal on the Law of the Sea. Of high relevance, I would say, it's the Paris Agreement Implementation and Compliance Committee side event at the UNFCCC pavilion here in Baku today at 1:30 that Christina referred to, and you just also referred to moments ago, Marie-Claire. Very timely indeed. Thank you very much. So now giving the floor back to Maeve.
Thank you. And with that, both Professor Marie-Claire Cordonier Segger and Professor Patricia Kameri-Mbote, you've both already been introduced, so it's a pleasure to hand over the floor to you now to chair the Climate Compliance on Trial plenary.
Thank you, Maeve. We're shifting gear, and we're welcoming some truly incredible legal leaders. Welcome, especially. We gather at a moment of unprecedented judicial engagement with climate change. Indeed, as of 2024, over 2,500 climate-related cases have been filed across more than 70 jurisdictions worldwide, with courts increasingly being called upon to interpret and enforce climate obligations. This past year alone has seen more than 250 new climate cases filed, and the highest annual number we've ever recorded. Perhaps it's not surprising, considering the incredibly important conditions in which we find ourselves for climate change today. Bringing together economic lawyers, such as Tom and Mike that we heard on the last panel, together with environmental lawyers, such as my honored and distinguished co-chair, and also human rights lawyers, such as Tanya and others who have joined us. Today, we have the extraordinary privilege of hearing directly from those at the forefront of judicial decision-making on international climate change issues. Courts and tribunals are not merely resolving disputes, but are also providing crucial clarity on the obligations that states, corporations, and all stakeholders have in addressing climate change. Through their decisions, they are helping to define the contours of climate justice as per the Paris Agreement and beyond, establishing precedents that ripple across jurisdictions and ensuring that climate commitments are not merely aspirational, but actually legally enforceable. I will turn now to my co-chair, Patricia Kameri-Mbote, an honored professor and, of course, director of UNEP's Law Division, for her open reflections to share. Please, the floor is yours.
Thank you, Professor Marie-Claire. I think we've had the role that judges and adjudicatory bodies are playing in promoting the environmental rule of law. If lawyers ramp up demand for climate justice, courts supply justice in diverse ways. It is encouraging to note that efforts to support effective environmental adjudication have increased as more environmental courts and tribunals have been established, and some really taken the gauntlet of climate litigation. People see courts, as Marie-Claire said, as both a sword and a shield in dealing with the changing climate and its impacts. Courts have risen up to the challenge, and these are courts at the national, regional, and international levels. Now we have key judicial decisions, such as the ones that Christina Voigt was talking about, and we are even expecting some. And these are informing environmental actions. We are expecting growing jurisprudence on climate. The United Nations General Assembly recognition of the human right to a clean, healthy, and sustainable environment in Resolution 76/300 in 2022 has had a catalytic effect and put wind in the sails of courts' efforts to address environmental degradation. I look forward to hear the contributions, and I hand over to you, Marie-Claire.
Thank you very, very much. And I should just mention that Professor Dr. Patricia and I were co-chairing an opening plenary in the Biodiversity Law and Governance Day in Cali, speaking about nature and nature-based solutions just a couple of weeks ago. And it's certainly an honor to be back with her today to talk about especially the role of international courts and tribunals here with such distinguished and crucial panelists who have joined us. We're honored especially to be joined by leading judges from the international courts and tribunals. And first, we will hear from Justice Anja Seibert-Fohr. She's a distinguished judge of the European Court of Human Rights, as well as, of course, a renowned professor. And this court is one of Europe's leading voices on human rights and climate justice. Her groundbreaking work on the United Nations Human Rights Committee, where she served as vice chair, has helped to shape the international understanding of states' human rights obligations in the context of climate change. As former chair of public law, international law and human rights at Heidelberg University, which of course is a renowned institution among all of us, she has been instrumental in developing legal frameworks that recognize the profound connection between human rights protection and climate action. Her visionary jurisprudence continues to influence courts and policymakers across Europe and beyond. We truly look toward her leadership among the voices and leadership of others in these crucial years. Professor Justice Anja, the floor is yours.
Thank you, Professor Marie-Claire, for your very kind introduction, and also for giving me the opportunity to share with you some thoughts on the relevance of human rights law for climate justice. It is a great honor to speak to you on this occasion about the contributions that my court, the European Court of Human Rights, has made to the protection of the environment, and more recently to climate protection. Although there is no specific right to a healthy environment in the European Convention on Human Rights, the Convention is increasingly being used by individuals and non-governmental organizations to help make progress on a wide range of environmental issues. The court has so far ruled on some 300 environmental related cases, applying various rights to a wide range of issues, including different kinds of pollution and man-made disaster. While these cases were usually related to environmental harm suffered by individuals and caused by local sources, the issue of climate change as a global phenomenon raises new, complex issues. The court had the opportunity to deal with those in its Verein Klimasenioren Schweiz versus Switzerland case. In this case, a Swiss association of elderly women who were concerned about the consequences of global warming on their health, as well as 4 individual women complained that the domestic authorities were not taking sufficient action to mitigate the effects of climate change. The major issue that the court was confronted with in this first climate case was the question to what extent individual human rights could be relied on to protect a matter which is in the interest of virtually everybody in the world. The Paris Agreement describes it as the climate change as a common concern of mankind. This raised several substantive and procedural issues. Up to then, it had been unclear which rights protected under the convention could be resorted to in order to oblige states to take climate action. It was therefore groundbreaking when the court recognized in its judgment of 9 April that the convention encompasses a right of individuals to effective protection by state authorities from the serious adverse effects of climate change on their lives, health, well-being, and quality of life. In this context, the court has introduced intergenerational burden sharing as a new concept. It recognizes that future generations are likely to bear an increasingly severe burden resulting from present failures to combat climate change. It is because of these irreversible adverse effects on the enjoyment of essential human rights by future generations that governments are legally bound by the convention to take action already now. To be more concrete, states are required to specify a target timeline for achieving carbon neutrality and to set reduction targets for this purpose. These targets need to be implemented, complied with, and regularly updated. In the case of Switzerland, the court found a violation on the convention because the respondent state had not acted in time and in an appropriate manner to devise and implement the relevant legislation, and thus had failed to comply with its protective obligations. Before I conclude, let me finally turn to the question how climate-related rights can be enforced judicially, while the primary responsibility lays with the governments, which need to take legislative action. This needs to be complemented by judicial oversight. The remit of domestic courts and of the European Court of Human Rights is thus complementary to those processes. For this purpose, there needs to be access to court in order to challenge these shortcomings in the implementation of climate-related measures. In this respect, the court has recognized the role of associations in climate change litigation as a means through which the convention rights of those affected can be defended. In the case of Switzerland, it found a violation of the right of access to justice because neither the individual applicants nor the association had been able to challenge the effective implementation of existing law before domestic courts. Moreover, the court has recognized that associations can eventually then turn to the European Court of Human Rights once they have exhausted local remedies to represent the individuals whose rights are or will allegedly be affected. While the current exposure of individuals to adverse climate effects is usually considered insufficient to reach the high level of intensity needed to claim to be a victim of a violation, it is the concept of intergenerational burden sharing which has prompted the court to recognize that associations may bring legal action and apply to the court not only in the interest of their members, but more generally in the interest of those seriously affected in the future. Well, this brings me now to the end of my short presentation of the court's recent climate-related jurisprudence, and I look forward to your questions. Excuse me, Marie-Claire, I cannot hear you.
Ah, there we are. I had to unmute. As always, thank you, Justice Anja Seibert-Fohr. We are delighted now to hear from Professor Thomas Cottier, who is, of course, one of the world's foremost authorities on international economic law and its intersection with common concerns of humanity and, indeed, climate change. As a frequent chair and member of WTO panels and a member of the MPIA pool of appeal arbitrators at the WTO, and as Professor Emeritus of European and International Economic Law at the University of Bern, Professor Thomas Cottier has influenced the development of international trade law to address global sustainable development challenges. His pioneering work as managing director of the World Trade Institute and as Switzerland's chief legal advisor during the Uruguay round, as well as his world-leading research on common concern of humankind, has established foundational principles for redefining how trade law can support climate action, for what Dr. Ngozi Iweala-Oyekunjo calls re-globalizing from a sustainable development perspective international trade. His scholarship and practice continue to guide the evolution of international economic law in service of sustainable development, and we're deeply honored that Professor Cottier has been able to join us here today. Thomas, the floor is yours.
Thank you so much, Marie-Claire and Patricia, for inviting me to this amazing and encouraging meeting in difficult times here. I would like to seize the short time allocated to emphasize the importance of the emerging principle of common concern of humankind. You know that this principle has been recognized both in the UNFCCC, also in the Paris Agreement, and can help us to really find the foundations for, in particular, the duty to act, which is very new in international law on states in the field of climate change, adaptation, and mitigation here. You recall the emergence of the principle of sustainability, which step by step was established and is now firmly leading also the private sector action. You recall how the principle of common heritage of mankind and humankind emerged. And I think we should have the aspiration to use the principle of common concern of humankind in the same time to anchor the obligation to cooperate. As you know, there is no general obligation to cooperate in international law. It's all treaty-based, but here we have the chance to use it as a foundation for cooperation, because common concern, as I would define it, means it's a problem which can only be jointly solved. It cannot be solved independently by states. It needs cooperation. So it is the very foundation of transnational sustainability. Secondly, it provides the foundation of the duty to act. Professor Seibert referred to the Senioren judgment. I read it carefully. You mentioned in this judgment the common concern of humankind as an underlying motivation to move in that direction. I would argue it's actually more than a motivation. It should be actually the principle on which we act and we establish the duty to act. I think it's also a foundation then to bring about compliance and to build upon all the law of compliance, countermeasures, etc., against free riders, which is down the road here. So I think that was my first point. This is very embryonic. This is very at the beginning, but I think courts do have around the world the possibility to build up on this anchorage of common concern of humankind in the treaties, which are of great importance here. The second point I wanted to make is briefly about the work of the trade law. Of course, in the COPs and COP29, it's mainly about finance and it's about Paris Agreement, but we should not forget that other agreements remain of great importance. And trade law is absolutely essential to bring about climate change adaptation and mitigation measures here. And I think the main achievement which was done in the WTO is the shift from product standards to production and process methods here. More and more laws recognize that products are being compared with each other and treated on the basis of how they are being produced. And products produced in a sustainable manner are, in a sense, privileged over products which are produced on the basis of fossil fuel energies, for example. And this principle, which is essentially founded on national treatment and the exceptions of it, is now very well established and is informing a lot of work which is taken place in the WTO in the committees, often under the radar screen, because the political climate is rather difficult to move forward in the field. But let me conclude by saying that I remain optimistic for the reason that renewable energy in the transition is increasingly recognized by people as economically advantageous here. It's just less expensive to use products and processes produced with sustainable energy. And so the market, I think, will take over, and that brings me to the importance of the private sector. If we look at COP29, it's all about government funding, allocation of budgets, and we know how difficult this is. Governments may pledge, but they may be called back by their parliaments. So I think what lawyers should really do is to emphasize ways how the private sector could be encouraged to actually engage in transfer of technology and dissemination of knowledge here. And the idea I would like to put out is really to refer to tax breaks. So a company which is willing to transfer intellectual property by licensing to countries who would not able to fund it commercially should receive a tax break by their own government on the exportation or on the investment abroad here. We do have already a system of patent boxes, mainly in Europe, which privileges intellectual property income, corporate income, but that could be further elaborated and could be extended actually to measures of climate change adaptation, which is at the very forefront of the needs of developing countries. We should not forget that this is where the money should go mainly in developing countries, less so on climate change mitigation, which remains the main responsibility of industrialized countries and emerging economies here. So let me stop with this and reiterate, please do support, do work on the principle of common concern of humankind. This is the key area where lawyers can make a difference. This is where judges can make a difference, where advocates can make a difference, independently of the diplomatic process here. And instead of just reporting and following what diplomats are doing, we should turn to the genuine contributions our profession can make in this field. Thank you very much.
Thank you very much, Professor Cottier, for your very insightful comments. We are now delighted to have with us Justice Kathy-Ann Brown, who is a judge of the International Tribunal for the Law of the Sea. She is a leading voice on global dispute resolution and maritime law. She was the permanent representative of Jamaica to the International Seabed Authority and has served as the Chief Technical Advisor to the Prime Minister and Deputy Solicitor General, International Affairs, Attorney General's Chambers, Jamaica. She has served as the counsel in disputes before the Caribbean Court of Justice and the World Trade Organization, and as a panelist in WTO disputes. She also holds multiple teaching and advisory positions across the West Indies, Guyana, London, Brussels, and Geneva. Welcome, Kathy-Ann Brown.
Thank you for the opportunity to share a few brief thoughts with you. As a judge on a tribunal which prides itself as being the guardian of the UN Convention on the Law of the Sea, the Constitution for the Oceans, I measure compliance not only from the perspective of the climate treaties. We should not lose sight of other treaties such as UNCLOS, as well as general principles of international law, which establish rules binding on all states to protect the environment from the impacts of climate change. The IPCC's sixth assessment report asserts with medium confidence that climate-related litigation by governments, private sector, civil society, and individuals is growing, and in some cases has influenced the outcome and ambition of climate governance. The three recent requests for advisory opinions from international courts and tribunals seeking clarification of the obligations of states to protect the environment from anthropogenic GHG emissions under the UNFCCC, Paris Agreement, human rights treaties, UNCLOS, and general international law take advantage of this non-adversarial procedure to draw attention to states' obligations and promote implementation of climate commitments. There is an implementation deficit fueling the ecological crisis. Climate change has the characteristics of a collective action problem. The IPCC tells us that most GHGs accumulate over time and mix globally, and emissions by any polluter affects everyone, and that effective mitigation requires collective commitments and is not served by individual actors advancing their own interests independently. The international obligations on taking measures to mitigate climate change are largely due diligence obligations. the content of which should be determined objectively in the circumstances, taking into account relevant factors. The standard of due diligence is stringent in light of the risks and projected adverse impacts and related losses and damages from climate change. However, given the differing capabilities and available resources, the measures states implement may vary. UNCLOS and the Paris Agreement both call for financial and technical assistance to enabling developing countries to do more. Climate change is a collective problem, but each state bears individual responsibility. The law recognizes that the conduct of multiple international actors together may result in an injury that none could have caused on its own. In situations of cumulative contributions, it will have to be determined which conduct constitutes a contribution that engages international responsibility. It may be that a course of conduct is determined to be a contribution that engages responsibility when it constitutes a material contribution to the injury. In the case of climate change, it has been suggested that it is sufficient that the activity contributes to increase the risk of harm. The evidentiary challenges of establishing causality should be distinguished from the applicability of states' obligations to mitigate climate change, including the well-established principle of harm prevention, which is now part of the corpus of international law and an important UNCLOS obligation. UNCLOS requires states to take all measures necessary to prevent, reduce, and control pollution of the marine environment by anthropogenic GHG emissions from any source. Specific obligations are imposed on states with respect to transboundary pollution, which go beyond the principle of harm prevention. The UNCLOS obligation is directed at preventing the spread of pollution beyond areas where a state exercises its sovereign rights. It is not limited to situations where damage has actually occurred, but also where damage is only likely to occur in the future. The IPCC has told us with very high confidence that the risks and projected adverse impacts and related losses and damages from climate change escalate with every increment of global warming. It is the existential threat of climate change that mandates climate compliance. The Paris Agreement and UNCLOS are complementary and highlight the climate-ocean biodiversity nexus. While the Paris Agreement complements UNCLOS, the former does not supersede the latter. UNCLOS obligations on the protection of the marine environment from climate change impacts may not be satisfied simply by complying with the Paris Agreement. This depends on how states formulate their NDCs, reflecting their highest possible ambitions. The IPCC reports indicate that governments are nowhere close to the level of ambition needed to limit climate change to 1.5 degrees Celsius. Neither are states' adaptation measures adequately directed at protecting blue carbon ecosystems that can play a key role in climate change mitigation. The 2024 Ocean Dialogue highlights the non-alignment between nationally determined contributions, national adaptation plans, and national biodiversity strategies and action plans, which do not sufficiently reflect the climate-ocean biodiversity nexus, and calls upon states to incorporate robust ocean components into their NDCs due in 2025. Climate compliance is all about states following through on the commitments they make. Thank you so much for your attention.
Thank you to Justice Kathy Ann Brown, who is currently in Kingston, Jamaica, where I understand it is around 1 o'clock in the morning. And so I deeply, deeply appreciate her care and attention in providing a video address to us all. We are especially honored to have all three of these leading justices with us. And because they have kindly agreed to make this opening high-level plenary on international courts and tribunals as engaging and participatory as possible, we have a few questions for them on behalf of the international audience that is watching, and also, of course, the International Circle of Climate Law and Governance Initiative here at the COP and all over the world. So I'm going to turn first, if I can, back to Justice Kathy Ann Brown, and especially to highlight that on behalf of those watching online from all over the world, we have received several questions asking whether, in her view, world-leading courts and dispute settlement mechanisms may need to contribute to resolving further conflicts arising in relation to climate change. And if so, what customary principles can guide them as climate change intensifies globally? And I understand that, of course, having been the Solicitor General of a small island state, she may have specific views on that. So I wonder if we could share her answer to that question, which we sent her at a much more human time earlier this week.
I'm glad that you raised this issue, as the requests for advisory opinions on climate change from ITLAS and the ICJ were initiated by small island states. The ITLAS advisory opinion was requested by COSIS, an organization of SIDS. This is not surprising, given the importance of the oceans and blue carbon ecosystems to SIDS. The advisory opinion is given to COSIS, but given the wide participation in the proceedings and the extensive discussion of the opinion in the legal and policy circles, it speaks to a much larger audience. A similar situation arose with the request for an advisory opinion submitted by the Sub-Regional Fisheries Commission, which is comprised of 7 vulnerable countries in West Africa. This provided the tribunal with the opportunity to clarify states' responsibilities with respect to IUU fishing. The clarifications provided in that advisory opinion have been cited in a wide variety of settings. The impetus for these advisory opinions from SIDS and other vulnerable developing countries is seemingly not only to clarify their own obligations, but also through a non-confrontational procedure to remind states with greater means and capabilities of what they are legally required to do. Courts and tribunals are not only there to resolve contentious disputes, but can clarify the law so as to assist states in making informed policy decisions. It might surprise you, but the tribunal, with the generous financial assistance of countries such as South Korea, Japan, and China, hosts various capacity building programs to promote good ocean governance. We see this as an important part of our work.
Thank you very much, Justice Kathy Ann Brown, for that response. I'd now like to pose a question to Justice Anja, and what I would like you to tell us is where you see the European Court's major achievements in the field of climate protection being, and what relevance the Court's new climate jurisprudence has for the UNFCCC.
Thank you very much for this question, Professor Patricia. Well, I think that the court's judgment in the Swiss case stands for an authoritative judicial recognition that anthropogenic climate change poses a serious threat to the human rights project. By recognizing an individual right to effective protection from the serious adverse effects of climate change, this right has become the legal benchmark for any government action in Europe. I would therefore say it adds an additional layer to the multi-level and polycentric system of climate protection. To be clear, this applies to all 46 states parties to the convention. But the court does not put itself at the place of democratic decision-making. Instead, it activates political processes and ensures that the implementation of climate justice and of climate legislation is subject to judicial oversight. Thus, while human rights litigation cannot substitute political decision-making, it strengthens the accountability of the relevant factors. Now to your other question, we should not overlook that the threshold for finding an individual rights violation is rather high, and that the obligations derived from the convention are essentially due diligence obligations rather than concrete, hard and fast rules. So the convention therefore does not replace the UN Framework Convention on Climate Change and its protocols. And I would like to emphasize that for us, as the European Court of Human Rights, the primary benchmark remains the individual rights, and I've tried to explain how we have translated climate protection into our framework. So neither is it the role of the court to apply and enforce the rules adopted under this framework. Instead, I see the role of the Common Court's climate jurisprudence above all as complementary to the Paris Agreement. It re-emphasizes the need for political action and subjects such action and its implementation to independent oversight. So on this note, I would like to thank you again for inviting me to speak at this important event, and I wish all participants of the COP29 a successful conference.
Thank you so much, Judge, Professor, Dr. Anja, and your insights are deeply appreciated, both in your understanding of the law as it actually occurs in practice on the International Tribunal, where your court is leading the way for us all, but also your deeper analysis as a renowned academic in this area. I will turn now for our final question to Professor Emeritus Thomas Cottier, who is, of course, not only an eminent jurist, but also a very dear friend, and quite fittingly, a Swiss individual who I'm certain was watching the jurisprudence of Justice Anja's court with great interest as a very dedicated grandfather. In your view, Professor Cottier, are leading international dispute settlement mechanisms serving to remind countries of their treaty promises and principles, and in curating respect for these norms? And further, this is a question that has come from many of our online audience. As a highly respected judge and professor, what advice would you give to young lawyers, especially those from highly climate vulnerable countries, including in the West Indies, of course, who aim to make a difference in the world like you have? Professor Cottier, the final words are yours.
Well, thank you. Thank you very much for the two questions. As you said, I really follow the Swiss case in the European Court on Human Rights with great interest, and I also noted the political reactions we got from it, that the court is overstepping here and is actually moving into territories which are not its own here. And I think it's a very delicate path. Courts of law have to proceed in this field. I mean, human rights courts face the problem that, as Professor Seibert said, that on the basis of individual claims of people as individuals here. And of course, in the climate field, we always have the problem of actio popularis, that you basically are not particularly affected, more affected than others, and that also was the problem in this particular case. And this, in fact, is the main reason also why I personally believe we should rely more on legal principles like the CCH principle rather than individual rights. But of course, every court needs to pick up on the jurisdiction it has and build it from there in a very delicate process here. Courts of law have to be very careful in the climate we're living, not to engage in political activism. I think we have to, particularly international courts, they have to stick with the wording and take it from there. I think constitutional courts, who have more authority, have more leeway to actually put the purpose of law at the center, but in international in the field of international law, this is very limited, and we have to take it step by step, very carefully here. My advice to people developing their skills, their legal skills in the field of these challenges is to focus not just on one layer of governance, let's say just on domestic commercial law, or then others just on international law, but actually to look at the law as such, as a multi-layered system. One needs to be able to go back from domestic to international issues and to combine these. So that's a very important prerequisite in training, to receive a broad training, then which will enable you then to turn to specific issues. As a lawyer from vulnerable parts of the world who are affected by climate change, I would actually focus my effort on climate change adaptation. This is where really efforts need to be made, and I would work on creating appropriate framework conditions like the one I mentioned about transfer of technology, knowledge dissemination in the field. To think about seeds who are able to survive in changed climate conditions, etc., and to work on that. And you see, this brings you together with public international law, with commercial law, with intellectual property law, etc. And if you have a broad background in your education, you're able to address these complex problems and make your contribution. Thank you.
Thank you, Professor Thomas Cottier. An answer worthy of one of the world's most eminent international trade lawyers, certainly. I think we need to recognize especially the world-leading progress that has been made last year as well as this year in the legal super year on climate change. Not just the work that can be done in public international law in the international trade tribunals, but especially, of course, all over the world, the regional human rights courts and how they have come to the forefront in recognizing and defending, as you said, in their area of jurisprudence, in their area of jurisdiction, the individual rights of all people. Indeed, I remember in the Fiji COP in Suva, meeting with the UN Human Rights Commissioner of the region, she explained to me that she faced questions like the ones that you have so tactfully recognized. And her answer in the Pacific Islands, of course, was to say, "Oh, well, what are the human rights implications, and why am I involved? Well, my friends, of course, here it is the right to life." And I think that was probably one of the most powerful and clear answers I have heard from my colleagues from the human rights tribunals worldwide as to the importance of their work. I will also, of course, directly and especially recognize not just the importance that Tom and Mike on the earlier panel underlined of international economic law, but also the law of the sea and Judge Kathy Ann Brown's work together, the work of her entire tribunal, and indeed her treaty regime, which she underlined. We all look to the Seabed Authority case with great respect in our analysis of the jurisprudence of her court and tribunal. So I will say thank you, deepest of thanks, to each of our distinguished speakers who have joined us for the grand opening and high-level plenary, Climate Compliance on Trial. We are deeply and truly grateful to you all, and we need you very much in what you're doing. Thank you not just for joining us today, but indeed for all of your efforts. This has been a truly inspiring and visionary way to start the 2024 Climate Law and Governance Day, particularly in these extremely troubled times. And we are looking forward to continuing to grow this inspiring global and crucially important circle of law and policy leadership worldwide. Indeed, it is an honor and a pleasure to announce and to sneak preview celebrate some excellent news which just arrived to us this week in the COP29 and is actually a tribute to you all, including everyone who has joined us this morning online. As pledged by the Climate Law and Governance Initiative Program Committee and our entire community in Glasgow at COP26, we have indeed managed to move the dial from 600 to 6,000 registered climate law and governance specialists in the new Climate Law and Governance Capacity Registry. We passed the 6,100 mark from over 120 countries actually just this week. So congratulations, everyone. This surge in capacity arrived just in time as countries are committing to our next rounds of nationally determined contributions to the global response to climate change. This will hopefully help us to bridge the gaping climate law capacity chasm beneath our feet, providing a registry of specialists worldwide in all of your countries and jurisdictions to help ready and determined to contribute to implementing the Paris Agreement. And this is, of course, essential, as one of our two Masters of Ceremony showed several years ago at the University of Cambridge with CISDL in her world-leading research project that we did together. 169 out of the 186 nationally determined contributions in the last round explicitly depend on legal and institutional reform to be able to achieve their objectives. And the capacity for that reform is now finally coming online and becoming available. So I commend you all and give warmest of thanks to our partners and our plenary keynotes. And with that, would like to hand the floor to our Masters of Ceremony for their guidance, with a special note of thanks, not just to the opening plenary speakers, highly distinguished partners whose collaboration we deeply value, but also especially to the world-leading judges who have joined us this morning to contribute their insights, as well as, more than anything, my co-chair, Patricia Kameri-Mbote, who is an inspiration to us all and will always be a kind and patient and truly deeply substantive expert and leader in this field. It has been such an honor to share this plenary with you. And I will turn to Ayman for the next steps. Ayman and Maeve, are you online to join us? I can see Ayman, but he's joining from the blue zone. Everyone is passing behind him in the COP, so he might only be able to unmute in just a second.
Sorry about that. Can you hear me now?
Yes, we can. Thank you.
Excellent. So we'll now proceed to a short break, after which we hope you'll join us at the appropriate Zoom links for the first of our concurrent expert panels, roundtables, and workshop sessions. Indeed, for the first time ever, certificates are available for participants in the day if you join at least 4 sessions in person over Zoom during the symposium and complete a brief evaluation over a link you will receive just afterwards. As hosts, we are delighted to be able to provide this valuable recognition for participants who joined during the day. And our first session will taking place from 11 a.m. To 12:10 a.m. Azerbaijan time, which is 8 a.m. to 9:10 a.m. time Europe, and 2 a.m. 3:10 a.m. for those of us joining us from North America. And we're very happy for your courage and dedication for joining us so early by your time zone. Are certainly fascinating. There will be 2 legal roundtables. One, galvanizing global attention on the ICJ climate change proceedings, hosted by Pacific Island students fighting climate change and Words Youth for Climate Justice, and Advancing Global Accountability for Corporate Climate Action, hosted by Melbourne Climate Futures, University of Melbourne, Grantham Research Institute on Climate Change and the Environment, GRI, London School of Economics and Political Science, LSE, Department of Land Economy, University of Cambridge, and Centre on International Courts and Tribunal, University College London. We are also looking forward to a brilliant and crucially necessary participatory roundtable on enhancing climate resilience by securing legal rights for migrants, hosted by the Friendship NGO. To join the next sessions throughout the day, simply click on the relevant event Zoom link in the program that you would have received by mail as chairs, speakers, or registrants. Against warmest and welcomes, and we look forward to seeing you online throughout the day. As a reminder, the break will last for the next 12 minutes. We'll be back online 12 minutes from now. Thank you very much. Enjoy the break.